Okay, good afternoon, everyone. My name is Sophie Turrain, and I chair the British Association of Comparative Law, BACL, a network of about 50 universities in the UK. We're going to make a slow start, waiting for participants to join in a little bit. And I see the list is increasing. So this is the second of our webinars on comparative torts, and today's webinar on liability in tort for ecological harm in a comparative perspective aims to continue a discussion that started in the second edition of Marcus Smith's German Law of Tort, written by Professor Bell and Professor Jensen, both of whom are with us today. And the book publisher, as you can see on the slide, is kindly offering a 20% discount for the purchase of the book, and the code for the discount is on the slide. As yesterday, it is my role and privilege to introduce you to our panelists, our panel members today. I have less than a minute, however, to do the introduction, so we'll only say with great enthusiasm what I said yesterday, which is that we have leading scholars with us today, very well known to those interested in the law of torts in England, France, and Germany. Professor John Bell will first introduce the topic, followed by Professor Simon Taylor, Professor Jonas Netsch, and finally Professor David Howarth. And Professor Andre Jensen will manage the questions. And finally, I'm delighted that we have again a large and diverse crowd in the audience, more than 150 registered attendees with specialists and non-specialists alike. There should be at least 30 minutes for questions, and I very much look forward to that too. John, over to you.
Thank you. Good afternoon. The purpose of this seminar is to reflect on the broad question, is German law of delict fit for purpose today? To do so, we have a very specific contemporary challenge, the issue of compensation for ecological damage. We've structured the discussion by beginning with French law because it's recently changed its civil code to recognize ecological harm as a distinct category of loss. It thus challenges German and English tort laws, which have not so far taken this route.
We seem to have lost John.
This seminar is the contribution, if any, that tort law makes to law's engagement with the major public policy issue of our time. Our structure will be to invite first Simon Taylor to talk about French law, then Jonas Knecht to talk about German law, and then to invite David Howarth to talk about the common law. After these three speakers, there will be an opportunity for questions to the panel. I invite you to pose your questions in the Q&A function in Zoom. The Q&A will be led by Andre Jensen. He will read out your questions to the panel and invite responses. So it's my pleasure to begin by asking Simon Taylor to present. Simon is a maître assistant at the University of Paris Diderot, Paris 10, and he teaches at the École Normale Supérieure in Paris and the University of Bergamo in Italy. He's a member of the Sorbonne Institute of Legal Research and the Groupe de Recherche Européenne sur la responsabilité civile et l'assurance. So he's an expert on this, and we welcome him and look forward to hearing from him.
Thank you very much, John, and thanks also to Sophie and Isolde for inviting me to this seminar. Just something on what John said there. I'm actually professor at the University of Nanterre, in fact, now. Paris Diderot was a few years ago. So what I'm going to do in this brief talk is I'm going to restrict myself to the provisions on liability for ecological harm in the French Civil Code. And I'm going to then give some brief comparative observations on English law. So I think as an English lawyer looking at the French system, it's always striking to see the seemingly unrestricted scope of French civil liability law. Since it's not limited by any mechanism like a duty of care, a need for harm to fall within a specific tort, or for the need to show harm to a defined interest. French tort lawyers often also vaunt the capacity of their civil liability law to adapt to change. And the best known example of that is obviously the development of strict liability to deal with increasing accidents at the time of the Industrial Revolution. So recent developments in French law aim to adapt the law to dealing with the challenge of ecological harm. So I'm going to focus here on this specific concept of ecological harm. And if we define ecological harm as damage to nature itself, independent of any harm to individual interests, then it's obvious that traditional tort law rules are not adapted to doing this. Tort law is normally designed to provide individuals with compensation for their harm, and to deal with harm to the environment, we're going to have significant adjustments to the definition of harm, to defining who has legal standing, and to the appropriate remedies. So liability and remediation for ecological harm has been specifically provided for in the Civil Code in France since 2016. This followed a steady development of the doctrinal movement arguing for tort liability for ecological harm. And from 2008, the idea of liability for ecological harm was also given constitutional legitimacy by means of the environmental Charter. So this concept of ecological harm was taken up most notably in the ruling of the in 2012, following the damage to 400 kilometers of Brittany coast as a result of the Erica oil tanker disaster at the end of the 1990s. Along with liability to local authorities and NGOs, economic loss and moral harm, the court in that case imposed liability for ecological harm on the owners and charterers of the ship. And that represented 13 million euros out of a total of 192 million euros for civil damages in that case. Tell me if I get completely cut off. The new Articles 1246 to 1252 of the French Civil Code codify the concept of civil liability for ecological harm, and the principal provision states that any person responsible for ecological harm is liable to repair that harm. So how is ecological harm defined? Well, I think this is quite important. Ecological harm is defined as one of two things. It's either a non-negligible adverse effect on the elements or functioning of ecosystems, or an adverse effect on the collective benefits that are drawn from the environment by man. So the first category would include harm to plants, animals, microorganisms, and their non-living environment. And by collective benefits, the legislation can be seen as referring to services that the environment provides to mankind, such as pollinating, capturing carbon dioxide, climate regulation, and retention of rainwater. It could also include providing man with food, materials, fresh water, biofuels, even pharmaceutical products. So who has standing? Well, the French state can bring an action, the French Environment Agency, local authorities, and environmental NGOs. And individuals will presumably also be able to bring proceedings where they can show they've suffered sufficient harm, perhaps harm to their land, or even personal injury. Perhaps they could then tag on a claim for ecological harm. So the other major innovation is with respect to remediation. Repair for the environment is the primary remedy. And damages are represented as a secondary remedy, only where it's impossible for the responsible party to remedy the environmental harm. So the legislation states specifically that any damages paid to the claimant are to be used to restore the environment. And where the claimant is not able to take adequate repair measures themselves, the damages will be paid by the to the state in its place, which will in turn be required to use the damages for environmental restoration. An important point as well is that the legislation also provides for the prevention of future damage. So expenses incurred in preventing the imminent occurrence of damage or avoiding it getting worse or to reduce its consequences also constitute compensable loss. So how do these new tort provisions in the Civil Code meet the challenges posed by ecological harm? Well, there has so far been a limited uptake of the new provisions. Less than 10 claims for ecological harm were brought before the French courts between 2016 and 2019. So this relative lack of success can be explained perhaps by the considerable challenges in using civil liability law to deal with ecological harm, which the new legislation has not really been able to efface. The concept of ecological harm is very different, is a very difficult one to pin down. The legislation does not provide any detail as to the heads of damage, which makes it difficult for claimants to formulate claims and for judges to assess the harm coherently. There's probably an understandable reluctance by environmental NGOs to assume the responsibility of potentially extremely complex tasks of reparation of environmental harm. And establishing causation is obviously also going to be a particularly difficult point. So I'd like to look at a recent decision from the Marseille First Instance Court, which illustrates some of the difficulties in applying civil liability law to this type of harm. So over a number of years, poachers in and around the Calanque National Park on the coast near Marseille had captured sea urchins, octopus, grouper, and other species, some of which were protected. And the national park joined the prosecution of the poachers as a civil party and asked for damages to compensate both its moral harm and ecological harm. In a judgment on the 6th of March 2020, the court ordered, alongside damages for the park's moral harm, the defendants to pay a total of €350,000 to the park in damages for ecological harm. So I think the case shows that in many cases, it won't be possible to use the primary remedy, repair. Here it was not possible to require the poachers to reconstitute the environment. And this meant that the court had to undertake the difficult task of calculating the damages payable to the claimant national park for ecological harm. So in order to make this calculation, the court chose to evaluate the ecological harm by using concepts from ecological science. It considered that it was necessary to take into account the importance of each species for the balance to the ecosystem. So the calculation therefore took into account the biomass of the different specimens had to absorb to grow. So for example, a grouper, which is a really big fish, had to absorb 10 kilos of prey to form 1 kilo of its body weight. By reaching an evaluation based on the biomass and the area affected, the court combined this with the data provided by the park, and they reached this figure of €350,000. So the court will probably not claim that their approach is perfect. So it notably seems that animals at the top of the predatory hierarchy through the calculation of biomass were given greater importance, whereas this doesn't mean they actually had a more significant role in the ecosystem. And it's also notable that the claim was brought on the back of a public prosecution which means that the claimants benefited from the state paying the costs, and also from things like wiretaps, which the police had used as evidence against the poachers. So far, therefore, despite the quite audacious extension of tort law demonstrated by the new provisions, the impact would appear to be relatively small. But I think there's a more significant impact maybe elsewhere, because a recent, much publicized decision by the Paris Administrative Court in what's called l'affaire du siècle demonstrates the potential influence of this principle outside the immediate sphere of private law. In that climate change litigation, a claim was brought in the Paris Administrative Court by 4 NGOs against the French state for failure to respect its commitments to reduce greenhouse gas emissions. So in a recent decision on 3rd of February this year, the court found the state liable for ecological harm based on the new provisions of the Civil Code. That ecological harm was defined as climate change and interference with the ecological role of the climate. So the court ordered a further hearing to consider evidence to identify the appropriate measures to be imposed on the state. Now, for me, I think this is a very broad, clearly a very broad approach, which is taken here to causation and harm. And for me, we've really stepped outside what I would consider as tort law. So just to conclude, I'd like to make a couple of comparative observations. So I think English law, as it stands, is not adapted to dealing with ecological harm in the same way. Tort law in England doesn't recognise ecological harm as a distinct concept. And tort law is really only indirectly green, I think, in England. Any protection of the environment is achieved indirectly through remedies to address harm to individuals or to their land interests. So could we imagine English law developing in the way the French law has developed? Well, I think it's interesting that, as with the development of French law to deal with the consequences of the Industrial Revolution, the French courts played an initial important role as a motor for subsequent legislative reform. It's difficult to imagine case law development of the concept of ecological harm in English tort law. There's a reluctance of English judges to develop tort law in an area where public regulation is seen as more adapted. And that was a view expressed specifically by Lord Gough in the Cambridge Water and Eastern Leather case in 1993. And this is coupled with restraints on legal development in the common law systems through the nature of legal reasoning by analogy, which perhaps doesn't permit the same sort of big leaps in conceptual leaps as French law does. So the approach to legal rules by the French courts is more adapted to this more audacious legal development. The French higher courts are comparatively more willing to embrace concepts at an abstract level without being tied down to a need to carefully define that concept. So that gives certain dynamism and innovation to French tort law in its capacity to adapt to new challenges, even though that obviously then leads potentially also to inconsistency and uncertainty. So the dynamic nature of legal development by the French courts can also be explained by the frequency with which the French higher courts are called on to consider issues, which obviously the Supreme Court in England, for example, very rarely is called on to hear new legal issues, in fact. I think I'll just skip the next point, but just to conclude, I think one final remark I'd make is an important explanation of why we have ecological harm being recognized in the French Civil Code is that it's seen as giving considerable symbolic impact to the principle of liability for environmental harm. And this is probably an effect that would be more difficult to achieve in any English rule. It would in many respects have been advantageous in France to insert the provisions on ecological harm into the environmental code. And the choice to insert in the civil code was clearly a symbolic one. And that's reflected in the wording of the principal provision, which really does echo Article 1240 of the Civil Code on liability for fault. So this symbolic strength and abstract nature of the rule then facilitates the extension of its scope. And this can be seen in its subsequent adoption by the administrative courts. So the recognition of ecological harm in tort in France is therefore, perhaps most importantly, a way of influencing hearts and minds in the fight to protect the environment. And it wouldn't have the same effect, I think, in English law. So that's all I wanted to say for the moment. So thanks very much for listening.
Thank you very much, Simon. That was very interesting, and particularly the point you made towards the end about legal development and the symbolic role of the civil code within the French legal system. We now have a response from a sort of Franco-German perspective from Jonas Knetsch, who's professor at Université Saint-Étienne, but author of Haftungsrecht und Entschädigungsfonds, a comparison of French and German tort law. So he's eminently placed to consider what is coming out of France and how Germany has responded differently to the challenge of ecological damage. So Jonas, with pleasure.
Yes, good afternoon. And once again, I'm sincerely grateful to Sophie Turenne and Iso Marik for the invitation to this online discussion on German law of torts, and also to John Bell for his kind words. And what is more important, for the wonderful book he and Andre Janssen offered to the academic community. And so I was asked to represent Germany in this second meeting and to give you a short presentation on the legal perspectives under German law for the compensation of ecological harm. And during the preparatory meeting for this webinar, I indicated to the organizers that my academic background would rather lead me to deliver a French-German view on this issue. And I'm very happy that the organizers accepted this proposal. So the general question raised by Sophie and Iso is whether the German law of torts is still fit for the legal challenges of the 21st century. And so in yesterday's session, Ulrich Magnus and Gerhard Wagner exposed recent legislation about self-driving cars and other emerging technologies in Germany. And Jean-Sébastien Borghetti and I have tried to demonstrate that the French legislature follows a more cautious approach for now, and that legal scholars in France did not address all those issues which have become important in the German legal doctrine. Well, when it comes to the compensation of environmental harm, a comparative survey of French and German law may lead to the exact opposite. And that is why Simon and I suggested to start with French law during this second session of the online discussion. Indeed, unlike in France, the German parliament did not consider it necessary to introduce in the civil code, in the BGB, specific provisions on pure ecological harm, reiner Umweltschaden, as German lawyers say. As you may know, under section 823, paragraph 1 of the BGB, compensation claims are limited to the recovery for injury to life, body, health, freedom, property, or other rights of a person, which is interpreted very strictly by the courts. There is no reference at all to harm which can be inflicted to the nature as such or to the environment itself. So the first point that I would like to highlight is that the standard provision for extra-contractual liability under German law does not provide an adequate basis for the compensation of pure environmental harm. It only allows claims for compensation of environmental harm if one of the rights or interests listed under section 823, paragraph 1 was violated, for example, in cases of pollution of private farmland or of diseases suffered by cattle or by people. But even then, claimants have to overcome major legal obstacles, the proof of fault and wrongfulness, and what is even more complicated in some cases, the proof of a causal link between the defendant's action and the damage to one of those legally protected interests. As you might have heard yesterday from Ulrich Magnus and Gerhard Wagner, German tort lawyers, unlike their French counterparts, have a somewhat tense relationship with the idea of strict liability. Historically, liability without fault for environmental harm had been limited to certain particularly dangerous activities or facilities, such as nuclear power plants or mining facilities, and to water pollution. And it was only in 1990 that the German parliament enacted an Environmental Liability Act, Umwelthaftungsgesetz, according to which the owner of a hazardous facility is strictly liable if anyone suffers death, personal injury, or property damage due to an environmental impact of such a facility. But once again, this only concerns cases in which an individual right has been violated. And according to sections 5 of this act, the compensation of non-substantial damage to property is even excluded if the facility was properly operated. As for pure ecological harm, the German law of torts does not provide any specific liability regime, or like in French law, specific provisions on remedies such as reparation in kind or damages. One could mention the Environmental Damage Act of 2007, Umweltschadensgesetz, which is in fact the transposition act of the 2004 EC Directive on Environmental Liability, and which introduced into German legislation the concept of pure ecological harm. As in other European jurisdictions, legal scholars in Germany have pointed out the hybrid character of this regime, sitting at the midpoint between a private law-oriented liability regime and a public law regime linked to administrative police. As you know, the directive explicitly excludes private parties from the compensation of environmental damage. This also explains why German courts have so far not recognized the Environmental Damage Act as a protective regulation, Schutzgesetz, under section 823, paragraph 2 BGB, providing claimants with an alternative basis for a tort law claim, in case the violation of such regulation causes them harm. However, it is notable that the possible repercussions of the Environmental Damage Act on German tort law provisions are still under debate, and renowned tort law scholars have argued that this act should indeed be regarded as a protective regulation under section 823, paragraph 2. So, since traditional tort law regimes do not offer a sufficient legal framework for the compensation of pure ecological harm, and keeping in mind the attachment of German tort law to the idea of a limitation of protected interests, it is not surprising that the mere term ecological harm conveys different ideas in France and in Germany. Whereas a French lawyer would probably think of the Erika case mentioned by Simon and the 2016 Act, which introduced the concept of pure ecological harm into the Code Civil, a German lawyer would probably intuitively think of environmental liability in a broader sense, and in particular of cases in which private multinational corporations were sued by individuals for environmental harm. Which brings me to the last point of my brief presentation. One of the most interesting cases of the last years, often presented from the perspective of climate change litigation, is the so-called Juarez case. In November 2015, a Peruvian farmer and mountain guide filed a lawsuit before a German district court, considering that global warming threatens his property, and the RWE Group, a German multinational energy company, contributed for decades to the greenhouse gas effect and ultimately to the rise of the water level of a glacial lake situated above the claimant's hometown. Despite an extensive media coverage, this case is still at an early stage. In 2016, the District Court of Essen dismissed the case on the grounds that the claimant could not establish a legally relevant causal link between the greenhouse gas emissions by RWE and the endangerment of his property. But in November 2017, on appeal, the Higher Regional Court of Hamm in Westphalia accepted the argument made by the claimant regarding causation and issued a court order allowing him to provide more tangible evidence of a serious threat to his property, of the causal link between the defendant's power plants and global warming, as well as of the causal link between global warming and the melting of the glacier feeding the lake. And last but not least, the court asks the claimant to obtain expert opinions on the exact share of the defendant's action in the contributory causation, which, according to the claimant, amounts to 0.47%. While the symbolic character of this court order cannot be understated, it is also important for me to look at the legal basis of the farmer's claim, which brings me back to the initial question whether German law of torts is still fit for 21st century. I find it quite telling that the claim was not based on tort law, but on the so-called neighbor law, which derives from the law of things. In fact, according to section 1004 of the BGB, if the ownership is interfered with, the owner may require the disturber to remove the interference, and if further interferences are to be feared, the owner may seek a prohibitory injunction. Although there are obvious connections between this provision and tort law, on the field of causation, for example, one must recognize that the Juarez case is not a matter of tort law in the strict sense, which confirms that the German law of torts does not provide for now a suitable basis for civil liability in climate change litigation. That will be all from me for now. Thank you very much.
Thank you, Jonas. That was very interesting and showing a different perspective and perhaps the way in which German law operates, sometimes even outside the civil code in order to deal with problems, but certainly by using other provisions of the civil code outside the delict provisions. We now have David Howarth, who's Professor of Law and Public Policy at the University of Cambridge. Among his many achievements, and those include being a politician, he has written a textbook on tort and therefore is well able to talk about tort, but also is very much an environmental lawyer. So David, all yours.
Well, thank you, John. I should say I'm also a head of department in Cambridge, and so it's a great pleasure to be able to talk about something academic and intellectual for a change. So I'm very grateful to the organisers for inviting me. In some ways, what I'm going to say is a footnote to what Simon said. For a valid tort claim in English law, you need a defendant you can sue, and there needs to be a claimant with a recognised interest. And the first thing to say is about the first of those. It was interesting to hear Simon talk about actions against the French state under the new provisions. English law in the past decade or so, especially in the law of negligence, which is the main delictual doctrine, the equivalent of 1240 and so on. The courts have been very busy restricting the possibility of suing public authorities. The official position now is that public authorities can't be liable in negligence in circumstances in which a private individual would not have been liable. And even where a private individual would have been liable, the public authority can't be liable if that liability would conflict with the authority's statutory duties or the exercise of its statutory powers in any substantive way. So the effect of that is that public authorities can't be held liable in negligence for negligent failure to confer benefits, or for negligent failure to rescue people from harm caused or threatened by other people. And that's so, and this might be a surprise for German lawyers, that's so even where the framework of public law, which creates the power to confer benefits, for example, itself includes duties to protect particular types of people. So in what's now the leading case, GN and Poole Borough Council, there was no liability where a local authority failed to use its powers to protect a child from harm caused by other residents in the same district, even where those powers arose out of a statute imposing a general duty on the authority to protect children from harm. The court in effect said that the local authority had no duty to rescue individual children from dangerous situations, even though it did have a duty to protect children in general. So applying that to ecological harm, what that means is that even if ecological harm, and we'll get to this in a second, does give rise to an interest protected by English tort law, public authorities couldn't be held liable for failing to regulate the activities of other people, prevent the activities of other people, which have in turn led to ecological harm. So suing the public authorities is not very easy in England. So turning to the main question, the recognised interests of claimants, as Simon said, I think Jonas also referred to this, the initial question is, what do we mean by ecological harm? So if we mean the harms caused by pollution in normal course of events, in many circumstances, ecological harm is actionable, as Simon said, because pollution usually involves harm to health or to property. Although it's a restriction that Simon also mentioned, that only people whose own health or property, etc., have been adversely affected can sue. You can't sue in English tort law for harm caused to other people. Some limited exceptions to that, insurance companies and so on. But the central effect of that is that it wouldn't be possible for associations or NGOs to sue on the basis of harm caused to other people in tort. We'll get to public law briefly in a minute or two, which is where the situation is different. So, and in addition to that, English law doesn't allow negligence actions in respect of harm that is only feared. There has to be some harm. Future anticipated harm, very difficult to use as a basis for liability. Now, there is the law of nuisance, and interesting that Jonas was classifying what we think of as a tort as property law. This is a famous problem in classification, but in what we think of as the tort of nuisance, which protects the interests of landowners, where the concept of damage is, to quote a judge in a recent Court of Appeal case, elastic, then reasonable fear of future damage could be actionable, and there might be some basis for an action on the basis of threat to the amenity, use, or use value of land, although I should say not to its investment value. So where pollution is involved, then there is this indirect protection. But turning to the more general meaning of ecological harm, as Simon laid out in the French statute, going beyond pollution to things like harm to the common environmental patrimony of humanity, things like biodiversity and climate change, the situation is plainly more difficult for claimants. It is true that loss of biodiversity can be seen as threatening human health in the long term by, for example, reduction in the availability of some important ecosystem services, such as pharmaceutical development in the future. But the problem there would immediately be, even if that were recognised, the claimant would have to show that there was harm personally to them. And it's very difficult to see how that could be established. In other jurisdictions, you could imagine someone launching an action on the basis of loss of a chance in those circumstances, but English law doesn't recognise loss of a chance either. I suppose there is a faint possibility, returning to the nuisance action that Jonas raised, that a loss of biodiversity might affect people's gardens, and that might make those gardens less satisfying to own. And it's true that nuisance law does include a very helpful notion of cumulative non-divisible causation, under which anyone who contributes to creating a nuisance is liable for it, even if their own share of the creation of the nuisance wouldn't have been enough to cause actual nuisance by itself. So there are those points in favour of nuisance action, because this is all very speculative and no one's joined together these various dots. I suppose I should mention in passing the infamous tort of public nuisance that was attempted to be used by some litigants in the USA, where the law is actually very different. and attempted also to be used by litigants in New Zealand in the recent Smith case, Smith and Frontier Cooperative Group. The sort of public nuisance isn't anything to do with private nuisance. It's basically a rather French concept. It's a crime that you can sue on. It's the crime of annoying people, annoying the public at large without any justified excuse. The restriction, though, is that private individuals can only sue if they have damage greater than or of a different type from the public at large, and in a biodiversity action or climate change action, which is what Smith was, that wouldn't really be possible to use. So for biodiversity loss to be actionable, this indirect protection doesn't seem to work in negligence, and perhaps is a theoretical possibility in private nuisance, but that's about it. So as Simon said, the question then is, can the courts, common law courts, be persuaded to recognize biodiversity loss, ecological harm, climate change as actionable loss in a new development? And it is possible to do that. The English law does develop. Psychiatric harm has been recognized, not as far as well as many people would hope, but still psychiatric harm originally was ruled out and then was ruled in. We developed a tort of misuse of private information and so on. So big developments are possible. The question is, how likely are they? And I think the present state of play is they seem very unlikely. The New Zealand case that I mentioned, the Smith case, there was an attempt in that case to get a recognition of a new type of loss. We've got climate change in negligence, and the judge gave 9 different reasons for not doing so. And you could probably pick holes in all 9, and I'm sure some of them are not correct. But the important thing is there were 9 of them. That is, the judge was determined not to move in this direction. And a lot of them come down to the point that Simon made, that common law judges would prefer the political authorities to move first and don't want to get out ahead. But I suppose to give some sort of room for hope, I think the main reason for that is that the judges don't want to be ahead of public opinion. But public opinion in England and Britain on climate change, at least, is very advanced compared to the rest of the common law world. So I wouldn't entirely rule it out, but it does seem very unlikely. So 2 final points, though. I did say that the position in public law is different. Standing in public law in England is very broad, and so associations, NGOs, are able to bring public law actions against the state. They've not succeeded very well recently on climate change matters, for example, but there's no problem, there's no liminal problem. The parties can get their actions in front of the courts. And there might well be further developments in that direction in the future. And finally, just going back to private law to end on a more optimistic note, although developments in the courts are unlikely in this field, they're not that unlikely in legislation. And if one looks at the Environment Bill, for example, presently before Parliament, that bill includes, for example, a new possibility of covenants, restrictive covenants on land that can be created in favor of associations or NGOs to restrict activities on the land in respect of environmentally harmful activities, which can then run with the land, that even if the property is sold to a different owner, that restriction still maintains. And that can be seen as having something of the structure of the French statute. That's to say that there's a creation of a possibility of a liability liability in favor of environmental associations, which breaks through previous notions of what private law was for. So I wouldn't give up all hope on this, in this area. There may well be legislative breakthroughs, even if I don't think they're going to be case law breakthroughs. So thank you, John.
All right, thank you very much indeed, David. Andre Jansen will now deal with the questions. I noticed one or two questions have ended up in the chat, and I think Andre will be able to cope with that. Thank you.
That's right. So please feel free to answer additional questions. And so the first question is a question by Rick Peltz-Stiele. So the German neighbor law sounds like the Anglo-American nuisance. Is that accurate? So that is one working theory in American climate change litigation against big oil. Why would that not be regarded as a species of tort? Perhaps is it limited to injunction, or does it allow damages also? Somebody would like to respond? I think it's maybe addressed to Jonas, I guess.
Yeah, I will. I will say some words to this question. Thank you very much for this idea. Yes, of course, there are obvious links between the Anglo-American nuisance theory and what I call the neighbor law. You're absolutely right. I mean, in paragraph 2004, section 2004 BGB, only the injunction is mentioned. But when you think about the remedy of injunctive relief, I mean, there are also obvious links with damages, because in the Juarez case, what was asked of the RWE group was the financial contribution to protective measures to protect the claimant and the people living in the small village of Juarez from the overflow of the glacial lake, because the glacial lake was on top of the village. And so to contribute financially to protective measures, I mean, there is some equivalence to damages you may ask on the grounds of tort law, because both measures have the aim to prevent harm, and in some kind also to compensate some future harm. So there are obvious links, I think, between the remedies under the neighbor law and under tort law. But I think the question you have raised also shows that when assessing common law, German law, and French law on the field of neighbor law, you might realize that the remedies provided for those cases are not all in the same category in all those jurisdictions, because whereas a common lawyer would say, okay, nuisance is a species of tort law, in French law it is still disputed whether the trouble du voisinage is a part of tort law or is outside of tort law and closely related to the law of things and property law. And whereas in my impression, in German law, a German tort lawyer would clearly say that that nuisance is not part of tort law, despite the obvious connections with tort law. So that will show also that probably that there is some equivalence, but in the national tort law theories, the classification, the taxonomy is a little bit different between the different legal grounds of action.
Well, thank you very much. Now we got a lot of questions. That's very nice. So I'm just moving to the next questions. So that's the first. There is first question by Chris Hilton, and that question goes to David. I wonder if breach of statutory duty might yet be a way to provide for ecological harm per se, especially if a statute is designed around protection of an ecosystem and is therefore designed to protect that class. So that's the first question by Chris.
Well, I'm eternally gloomy about the use of the tort of breach of statutory duty. A tort that I attempted to expand in my textbook 150 years ago, whenever it was, and has failed completely. The problem is that the very strange English doctrine that if a statute provides some other method of enforcement, the courts are unwilling to create a tort out of it. And so a statute protective of biodiversity, for example, would presumably have some criminal provisions, and that will be used by the courts to say it's nothing to do with tort law. I know this always sounds like backwards to people from other legal jurisdictions where the existence of a crime is obviously a good reason to have a tort, but in English law it's the opposite. And there's also the very annoying possibility, so I hope I'm wrong about this and Chris is right, there's also the very annoying possibility that if you try to use, for example, the Climate Change Act, establishing targets for greenhouse gas reduction by various endpoints and various steps along the way, the courts will say, "Oh, I'm sorry, this is the remedy intended here is in public law, so you can't sue in tort." And then moving over to public law, say, "Well, the endpoint hasn't arrived yet, so you've got no action in public law either." And so I hope Chris is right, but I think if the only way to make sure this happens is for Parliament to create a statute which actually says in terms that this is actionable in tort.
All right, so then the next question also by Chris Hilson, and that question is for Simon. So on the French side, Simon, you seem to suggest that calculating damages the way they did in the national park case wasn't ideal because it prioritizes higher species. Would the cost-benefit analysis based approach to damages be preferable or not? Simon?
You've got mute on, Simon.
Sorry, I forgot to put on my microphone.
All good.
Yeah. Yeah, well, I think it all depends really what you mean by a cost-benefit analysis, and what I mean, the main idea, or what at least French law is trying to do, is to actually award damages which reflect the ecological harm, detached from any benefit to or any damage to individual interests. So that's why French law is using or trying at least to use ecological science to approach this question. And I'm not sure really how a cost-benefit approach would do that. My point really was, and I think is incredibly difficult really to comment on the way that the courts assess these things, because it's really a question of science at the end of the day, and I'm not really equipped to do that. But it just seems to me quite logical that the effect of each species on the ecosystem, the effect on the ecosystem as a whole, is the most important thing. And it seemed to me that just calculating biomass, or how much other elements of the environment that a fish consumes to make it full-sized, was quite a limited approach and didn't take all that into account. So, but to answer the question again, I'm not quite sure how this cost benefit would apply there to actually achieve that goal of really repairing the environment, in fact.
Okay, thanks a lot. So now we are moving to 3 questions by Francesca Leucchi, and she's a PhD candidate working on environmental damage assessment from the perspective of law and economics. So the first question goes to Simon, is whether the French law does provide clear guidance on the methodology to quantify monetary damages, such as price market-based contingent valuation?
Well, the answer to that is quite simple. It's no. In the lead up to the legislation, there was a lot of research done by academics cross-disciplinary work done on identifying heads of damage. And so what would constitute what we recognize as environmental harm. So there's been a lot of work done on that, but that's not referred to directly in the legislation. But I think judges will presumably have recourse to that when they're trying to assess the ecological harm. But there's no reference in the legislation to any methods of calculation. But that's also, of course, because the choice was made, as I said, for symbolic reasons as much as anything, to put the provisions in the civil code. And so by doing that, the French legislature adopted the style of the civil code, which is an abstract style, which obviously then leaves enormous amounts of room for interpretation.
Okay, thank you. So there is another question by Francesca, and that I think also goes to Simon. Secondly, I wonder whether there is a reference to use or non-use values of nature, like in the US, where natural resource damage assessment is quite accurate.
Yeah, I'm just reading it myself. I wonder whether it's a reference to
sure.
nature. Well, again, no. I mean, the code provisions are basically what I told you. They're really very brief, so they don't go into those sort of details. Now whether experts to the court are going after to be able to advise the judge to use those sort of techniques, I don't know, but they're certainly not something that are included in the code. I don't know whether Jonas wants to add something to that. Or...
Yeah, I mean, as for the calculation issue, I think it's very difficult. I mean, from the German point of view, it's almost a non-subject because I mean there's so few examples and almost none in which judges had to calculate damages for ecological harm. But what I find interesting under French law, I think you didn't mention it, Simon, was the attempt by a group of scholars to list different kinds of loss related to ecological harm. As some of you might probably know that in French law of damages, there is a clear tendency to develop a comprehensive list of damages. French tort lawyers are very fond of sort of categorized presentation of different heads of losses, especially in the field of personal injury. And there was an attempt a few years ago, it was about 5 years ago, to develop a sort of nomenclature, a sort of list, a comprehensive list of compensable items of loss in the field of ecological harm. And although this document did not have any important feedback in the case law, I think there was only one small case ruled by a district court in French Polynesia. It is quite an interesting attempt to progress on this matter. So to separate and to decompose the different items of ecological harm. But once again, I mean, it doesn't solve the core issue here. How can we calculate those different types of loss? I mean, that's another question, and this nomenclature I talked about doesn't address it at all.
Just perhaps, if I may, just to reinforce what Jonas said, that the document he is referring to is a really fascinating read, in fact, because it really is a way of actually realizing the enormous complexity of ecological harm and also the difficulties courts are going to face in actually evaluating what the ecological harm is, because it's all about interactions, obviously, between different species, different plants, etc. So it really is really a fascinating read. I'd recommend that to anybody who's interested in the topic. The authors are Laurent Néré, and it was Jonas, the other
Gilles Martin.
Yeah, Gilles Martin.
I will put the reference in the chat, so those who are interested can look about it.
Be great, thank you. And Francesca's last question, which I think is addressed to all speakers, is: well, thirdly, are judges in Europe equipped with sufficient competence on environmental damage compensation? Can we expect accurate calculations? I don't know who would like to.
Yeah, maybe I could start, because I could go back to the Marseille case. I mean,
I guess, yeah.
The judges were quite clear that, well, they basically based their decision on the arguments of the claimants. The defendants didn't produce any opposition to that. They didn't suggest any alternative themselves. So the court just sort of, I think, just held up their hands and said, okay, well, we'll use that as the basis of calculation. So I think, yeah, the judges are not sufficiently specialized at the moment anyway to deal with this type of problem. Obviously, a great weight then is placed on expert opinion. But yeah, I mean, there could be an argument for developing a specialized environmental court, I suppose. But yes, it's a very difficult task for judges, yeah, obviously.
Well, it's worth saying that the way judges all over Europe calculate damages with regard to personal injury is not necessarily how anybody else would do it. And there's a question about whether they've got the right methods to do that. In England, there's an undervaluation of life itself, notorious undervaluation of life itself, which, if you look at the other ways in which the public authorities calculate those values, are way below what would be acceptable even to people who are normally thought to be, very pro-free market and not really people who value life very greatly. So courts are inherently, whatever the type of loss, in a difficult position, just have to do the best they can. The question is, what should be the standard form in which evidence should be presented to the court? I mean, could we think of better forms of evidence, and would there be any rules that exclude those forms of evidence? And I think on the whole, there wouldn't be any reason for excluding the type of evidence that we've been talking about.
Okay, thanks. Well, to abuse my position as the moderator, there is also, for everybody who's interested in ecological harm, it's you should have a look also at the Chinese Civil Code, which was enacted this year, and it is full of ecological harm provisions, even with punitive damages for ecological harm and so on. But this is just a small additional information. Let's move to the next question, Emmanuel Lemaire. And the question is, the French Parliament is currently discussing a reform bill which, among other things, reinforces the protection of the environment from a criminal law perspective. It also considers the creation of a new specific criminal offense, such as ecocide, for example. If this bill was adopted, what effects, if any, do you think this could have on civil liability and or compensation for ecological harm? Yes, please.
Okay, well, maybe Jonas, we can sort of combine answers to this. I don't know. Well, obviously, the more criminal offences you create, one effect is that they're then considered as fault in civil law. So, I suppose to some extent it facilitates a civil claim if a civil claim was made. But also, obviously, it's another tool potentially in the fight for environmental protection. And I think we should see tort law as just one element of that fight. It's just one particular arm that the law develops. So obviously, criminal law is a strong weapon as well, which can be seen as working, I suppose, side by side. Jonas, have you got any?
Yeah, I totally agree with what Simon just said about the toolbox in environmental law, and I think this also refers to the question Paula Gillica has asked in the Q&A window. I mean, probably we will answer it a little bit more extensively in a minute or so, but. A while ago, we talked about injunctions and neighbor law, and when listening to all panelists, I thought that maybe in the field of environmental harm, the question is not so much whether the law of torts is fit for the 21st century, but the whole legal system is fit for the protection of environment. And indeed, I mean, tort law is only one of the tools available to civil society and even to the state. But we could also talk about tax law, about administrative law. I mean, David addressed it in his talk. Yes, so I totally agree with this idea. But to come back to the idea of Emmanuel on the link between criminal law and tort law, I think this is a really fascinating aspect of French tort law, this strong link between criminal and tort law, because it is really common for French courts, for French criminal courts, to apply tort law provisions on a day-to-day basis, because it is so common in France to file an action civile, so a civil compensation claim with criminal proceedings. And it is quite fascinating because, as Simon said, the more criminal offenses you create in order to protect the environment, the more you will use tort law before criminal courts in France. And what fascinates me is that in Germany, although that exists, although there is an equivalent to the action civile, the Adhäsionsklage, it is hardly used by German courts because criminal judges consider themselves not so competent in tort law issues. I don't know what other reasons may be raised to answer this question. But I think, once again, on the issue of environmental liability, this strong link between criminal law and tort law under French law is a positive asset for the protection of environment. Whereas in German law, it leaves the French tort lawyer a little bit deceived about this potential use of the interplay between criminal and tort law. I'm not sure that I was very clear in my explanations, but I tried to express my thoughts in English. It's not so easy.
Thanks a lot, Jonas. Next question comes from Paula Gillica, and that's, I think, a very interesting one. Can I ask a broader, deliberately provocative question? Should we be dealing with these as tort law at all, or should it be regarded as a matter of environmental law given the public-private nature of such damages? So I think that goes to everybody, to all the speakers.
Well, I suppose I should start. It's always seemed to me that environmental law includes tort law. In fact, it includes any bit of the law that's got to do with the environment. And what you at least need to do, from the point of view of public policy, is to ensure that every part of your legal system is aiming in the same direction. So what you don't want is for tort law to be contradicting public policy when it comes to fighting biodiversity loss or climate change. And so, although it might be expecting too much to be using tort law as an active method for environmental protection, the very least you should want to do is to make sure that your civil liability system doesn't contradict those policy aims. And so you want to get rid of bits of your civil liability system that encourage pollution, that encourage greenhouse gas emission and so on. And you need to look very carefully at things like the concepts of fault and concepts of damage to make sure it doesn't do that. So although it's obviously an interesting and useful point, it's one of the points made by the judge in the Smith case, that judges are not best placed to make, judges in civil actions are not best placed to make these judgments. It's certainly something that the legislature should consider, and I think it would be irresponsible of judges not to consider the negative effects that their way of doing things might have.
Okay, thank you. Somebody else? Thank you.
Yeah, sure.
No. Go ahead, Simon.
It's me then, is it? Okay. Yeah, I mean, it's a question I've been asking myself as well. I mean, as Paula said, is this really tort law? Because it's certainly on the sort of outer boundaries, perhaps, of tort law. In that, if we just take the civil code provisions, we're talking about actions by public authorities, actions by the Environment Association as well, but the Environment Agency, sorry. And we're obviously clearly outside the boundaries of tort law with respect to what we normally consider as loss. I mean, if we define tort law as liability for harm to individuals, if we define that as tort law, then clearly we're outside tort law. So when does tort law end, and when is this part of tort law or not? But again, why not be a little bit flexible, and why not add another potential action that will in some way hopefully help to promote environmental protection? So if that goes through a sort of hybrid, strange looking tort action, I think it's all to the better. All the tools we can use and find are going to be useful, I think, somewhere. Where you can give somebody an extra possibility for taking action. I think that's all to be taken, really.
Thank you. Somebody else?
Yeah, perhaps I may just add 2 or 3 things. So I already talked about this idea of toolbox, which seems quite accurate for me, and I agree with what Paul Gilliker said in her question. Maybe I can give just a few elements on some other forms of litigation, which is closely related to what we are discussing today in Germany, because I didn't have the time to talk about it and to address those issues. It is quite interesting to see that with the support of some NGOs like Greenpeace, for example, there are some litigation actually pending in different courts. So one of the cases was brought before the Berlin Administrative Court in 2018. It's a classical form of climate change litigation, but brought before an administrative court. And the claimants, who were 3 farmer families, asked for the administrative court to declare that the federal state had to take more substantial measures to protect climate, to protect the environment. And the Berlin Administrative Court, I mean, it took a lot of time for it to rule, to give a judgment on this case, but in October 2019, the Berlin Administrative Court rejected the claim in the first instance. An appeal is pending, and the Administrative Court said that the clients did not demonstrate that the federal state, through political action, falls below the minimum threshold of environmental protection. So this is the first case I wanted to address. The second case, it's probably even more interesting because it is about a constitutional complaint brought before the Federal Constitutional Court in 2020, when a group of young adults filed this constitutional complaint or appeal to Germany's Federal Climate Protection Act, considering that the goal of reducing greenhouse gases by 55% until 2030 was not enough, and that there should have been additional measures taken by the federal state. And so this constitutional appeal is still pending. The Federal Constitutional Court didn't give a ruling for now. So it will be quite interesting in the following months to have a look at this case. So I'm clearly not an expert of those cases. I just wanted to give the information to the participants on those cases.
Thank you very much, Jonas. Yeah, and to add on, so everybody who's interested in the last case of Jonas should also have a look at the Dutch Urgenda case, which probably you all know, but it's a Dutch Supreme Court case, and it's really quite spectacular, I think. But let's move to the next question. It's by Pierre Walker, and the question is, do you think that somehow the Environmental Liability Directive or any similar European instrument could lead to some form of harmonization of tort law and ecological harm conceptions between domestic legal systems?
Sure.
Who would like to start?
Should I sorry, David, you want to go, or should I go?
Well, I'll probably say I have no idea. And it's the previous attempts to harmonise tort as opposed to contract have not got very far. The systems are sufficiently different to make that a difficult technical task, and there's a lot of scope for lobbying for various interests. But who knows, with the British out of the way, anything's possible, isn't it?
Somebody else?
Yeah, perhaps I could just say something about the Environmental Liability Directive. I'm pretty skeptical, actually, as to whether that could be used as a form of some sort of harmonisation of tort law. First of all, the Environmental Liability Directive, as it stands at the moment, is not. We can't really call it a tort law provision because it's based on public authorities actually bringing the action. But also, I think it's interesting that the Environmental Liability Directive has not actually led, as far as I know, to any actions in French law. It's just not used at the moment in France. Whereas, and also in the UK, well, I know the UK is now outside the union, as David just said, but the UK also, I think, has had a relatively low uptake on the Environmental Liability Directive. I think there were 19 actions in the last study that were made. So
it largely overlaps other things, and therefore it's kind of pointless.
Yeah, that's right. And it also covers a very narrow definition of damage as it stands at the moment. So I'm not sure that that is a tool that could really be used for a harmonization measure, really, for tort law at least.
Thank you very much. If nobody wants to reply, I would like to move to probably the last question. That question is by Mark Wilde. And rather than to align tort too closely with the objects of statutory regimes and regulations pertaining to planning, etc., should we celebrate the fact that it focuses on more narrow private interests? Otherwise, it loses its capacity to correct regulatory failure where planners and regulators have failed to anticipate the impact on private parties and mitigate or compensate in advance? Who goes first?
Well, there's a lot to say about this. There's probably too much to say about this. You should go and read the Fen Tigers case and see what you think of Lord Sumption's judgment in that case. I mean, I think this is more about, as I said before, more about compatibilities. So plainly, different parts of the law, different legal concepts have different goals, different functions. And it's important not to sacrifice all of them to one single thing. On the other hand, it's important to try to make sure the system operates as a whole, and that the pursuit of particular conceptions of private law don't sabotage public policy goals that are very important. So some separation, I think, is important and desirable because there are multiple things going on, and in policy terms, you can't expect to achieve more goals than you have policy instruments. So I think that's a fair comment, but I wouldn't want people to think of private law as totally separate from the rest of the legal system, which I think some private law scholars do.
Okay, somebody else? You're all good.
Maybe just to add a point on French law. I mean, French law in some ways, I suppose, deals with potential conflict between planning law and tort law by saying that if you've got planning permission for your activity or your structure, then tort law can't actually impose, for example, an injunction to prevent that activity, because that's then interfering with public administrative law. So in that case, tort law is limited to an award in damages. So I suppose there is that limitation or protection inherent in the French system, I suppose.
And that's in effect the solution the court came to, if you read through the various remedy sections of their judgments. In the Lawrence case, in the Fen Tigers case, that's precisely where they've got to. That there can be a financial adjustment, but public policy is taken into account, planning is taken into account with regard to whether an injunction can be issued.
Yeah.
All right. So yes, Jonas, please.
Yeah, I've just thought of the. I would just react to the previous question. Sorry, my reaction is perhaps a little bit too slow, but the previous question was about the perspective of harmonization through the Environmental Liability Directive, and I think it's quite a tough question because in my understanding, the Environmental Liability Directive is a little bit underexploited, underused by tort law scholars, as far as I can see, in France, probably also in Germany, because sometimes a little bit too quick we say that it's not really a liability regime, it's a sort of public administrative police regime, so it's not really tort law. But the question that was raised leads me to another thought, because today we haven't addressed the issue of causation. I think there's a lot to say about causation, and the Juarez case and all the other climate change litigation cases raise the issue of causation. And I was thinking, maybe the harmonization issue that was raised is perhaps more relevant to causation than to the concept of ecological harm. And I'm wondering whether, for example, the case law on product liability and causation, which is really a hot topic in France for almost 10, 15 years now, can be transposed to a certain extent to environmental liability. So it would be interesting to compare the assessment methods in the field of causation between the European Union member states, and to look whether the European instruments, and above all the Product Liability Directive, has led somehow to not common practices. I think we're not already there, but we're still not there. But I think it would be worth assessing those methods, and probably the French law has a much more flexible approach than the German law. But when you reconnect it to product liability directive, because in French law, the recent developments on causation are mostly based on product liability, then you can raise the question, but why does the German law does not apply the same causation rules as in France, because it's the same legal base, product liability directive. So that would be quite an interesting point. I'm just getting it. So it's work in progress, if you want. But sorry, it's perhaps my answer's perhaps a little bit out of topic, but it goes back to the previous question.
No, well, thank you very much. I think, well, causation is without any doubt one of the key aspects. Thank you very much. And I think, well, you gave us a lot of food for thought, and probably even I could ask for several more hours, but nevertheless, I would like to thank you, and now like to pass the word back to John. Thank you very much.
Thank you very much, Andre, and thank you, colleagues, for your contributions to the questions. This has been the best BACL activity in the 36 years that I've been coming to its events. The imagination and organizational skills of Sophie Turenne and Iseult Maric have brought a rich debate about the ability of tort law to deal with contemporary problems. We've seen that ecological harm is very much work in progress. There may be legislation in France, but it's still in its early days to see whether it has real impact. The French legislator does like symbolic legislation. So the more practical approach, perhaps, of German law and English law may not be as far away as they might first appear. The questions are very much, what do we want to compensate and how do we want to do it? And that leads us to questions, as we've seen, about the whole toolkit that the law has available. I'd like to thank the speakers for their fascinating introductions to this topic, and to the audience for well-focused and illuminating questions. This event shows the need for debate on this topic, and that's why BACL has stimulated this session as a starting point for further discussion between the different legal systems represented here. So thank you very much. I'll pass back to Sophie.
Thank you very much. Thank you very much, John. I think your comments made my day. And so I just would like to add my thanks to yours and give some very warm thanks and express my gratitude to our panelists and the attendees for this an absolutely truly fascinating discussion yet again, and for some excellent questions and contributions from everyone here. As John said, this is a starting point, and I would like to say that BACL would very much like to continue exploring ecological harm in a comparative perspective. So I would like to invite everyone potentially interested in joining us for activities on this topic to contact us. It's about publishing a blog. It could be arranging webinars on more issues in this area. So please do feel free to get in touch. And that's it for now. So thank you very much. And bye-bye.
Thank you, everybody.